think we can get proceedings underway. Welcome to hearing 5 of submissions on the proposed district plan for the Selwyn district, and this is the transport hearing. So good morning and welcome. I just think we might commence with just a quick series of introductions in case any of you are new. So if we start on my left, Nicole, intros.
Nicole Reid, I'm one of the Selwyn district councillors.
And I'm Rob Van Voorthausen, Independent Hearings Commissioner based in Napier.
Lindsay Dyche, Independent Hearings Commissioner based in Wellington.
Tēnā koutou katoa, Yvette Couch-Lewis, a iwi Commissioner, Independent Hearings Commissioner. Kia ora.
And now the council officers, starting over here. John, you don't have to wear your mask when you're talking into the microphone. That's a local rule, apparently.
So my name's John Trewin. I'm the Section 42A author for the transport topic.
And I'm Anne-Marie Head from Abley, and I'm supporting John on the transport chapter.
Thanks for that. And on my left. Welcome to the team, Grace. Grace is new today to the role. All right, so the first submitter on our schedule today is what we are referring to as the Carter Group. I hope you don't mind. And good morning and welcome. I think you've been to at least one or more hearings, so you know the drill. Thank you very much for your pre-circulated material. You don't need to read it out loud to us. But you're welcome to introduce your team to us, and I see you've tabled material, and as before with table material, happy for you just to read that out to us, and then we'll see if we have questions for any of you. Thanks.
Great, thank you. My name is Lucy Forrester. I'm a counsel for the various Carter Group parties today. I won't read out the legal submissions, which were quite brief and more of an introduction as to the witnesses. Anyway, but I'll introduce you to Mr. Jeremy Phillips, who's our planner, and Mr. Nick Fuller, who's our transport expert. I've just handed out some summaries of their advice, which they'll be reading, and I'm here to answer any questions at the end if you'd like.
Thanks, Ms. Forrester. I'll just see if we have any questions from the legal submissions. As you notice, they're quite short and more or less a summary, but I'll just check. Nicole, any questions?
No, thanks.
Lindsay?
No.
And Yvette? No, me neither. Thanks.
In terms of batting order, we thought it might be useful for you to hear from Mr. Fuller first and then finish with myself. So my name is Nicholas Fuller. I'm a senior transport engineer at Novo Group Limited and have worked on resource management, transport planning and engineering projects for 20 years. I summarise the main points of my evidence in chief below. Restricted discretionary status. The submitter sought that all rules in the transport chapter be amended to specify that non-compliance shall result in restricted discretionary rather than discretionary or non-complying status. I consider that the discretionary status of certain rules in the proposed plan would open the consideration to matters beyond those that are associated with the effects of the non-compliance. As such, non-compliance with these transport rules and requirements should be limited to restricted discretionary. I accept the officer's assessment that discretionary activity status is appropriate for Tran R1 and Tran R2, given the broader scope of these matters. However, I consider the following rules and requirements should hold restricted discretionary activity status. And I'll take that list as read. Non-notification clauses for transport rules. I agree with Mr. Phillips that applications under rules TranMat 1 to TranMat 5 and TranMat 7 to TranMat 9 should be determined by council alone in its capacity as the consenting authority, with the scope for limited notification confined to Waka Kotahi and Kiwi Rail, where applications relate to state highways or rail crossings as relevant. Assessment matters. I consider it appropriate that additional restricted discretionary assessments include a reference to TranMat 1.7, which requires consideration of any characteristics of a proposed activity or site that make compliance unnecessary, including expected traffic generation volumes and the types of vehicles. The above allows for consideration of the specific details of the proposed activity that may negate the need for compliance. The officer's report rejects this submission, although acknowledges there are some rule requirements where flexibility should be provided. I consider it appropriate to include Tran Mat 1.7 as an assessment matter for the following non-compliances, and I'll take those as read. High trip generating activities. I consider it appropriate that the existing level of traffic generation associated with an activity be acknowledged and discounted from determining the traffic generation and floor area thresholds associated with the high trip generating activities rule. I consider it appropriate that an advice note after Tran Table 2 in Tran R8 provide for existing activities. The wording proposed would address the officer's concerns. And the wording was, note for Tran Table 2, for existing activities, the level of trip generation and scale of activity that existed prior to the plan becoming operative will not be included. Further, my evidence considered a number of examples of district plans dealing with trip generation thresholds and considered that the various thresholds contained in Tran Rec 2, Tran R4 and Tran R8 should be consolidated into Tran R8, being the high trip generator rule, and rely on its thresholds of 50 and 120 vehicles per hour for a basic and full ITA respectively. And minor correction to Tran Table 7. Tran Table 7 sets out the road formation standards required by the proposed plan. I note that the officer's report identifies a minimum legal width of 20 metres and a maximum legal width of 15 metres for these roads. I assume that the reference to a 15-metre maximum width in the officer's report is an error, with the notified maximum width of 25 metres being retained. This is because the officer's report has a maximum of less than the minimum, and the alteration has not been annotated as a change.
Thank you, Mr. Fuller. I'll see if we have questions for you, Lindsay. We'll start with you.
Yeah, just a couple. Paragraph 13 of your evidence in chief, you talk about reverse manoeuvres and so forth, particularly onto arterial roads. Can you say there may be circumstances where reversing onto an arterial road may be acceptable? What would those circumstances be?
I suppose, I can think of examples at the moment where it already occurs. So if somebody was redeveloping a house that was onto an arterial road and they wanted to retain the non-compliance, then that's something that is within the remit of the current effects of that activity. There may be other examples just off the top of my head. To be frank, I do struggle to think of any that come up, but whether it's a utilities service or something that has a small loading bay that's used once a year, something like that.
Okay, so really that does relate to whether something that's existing present. But if you're looking at a new development and it's onto an arterial road, the default is you should be able to turn around and move in and out in full direction. So, I take the point in terms of non-compliances there, but it could be that there are circumstances where you would probably struggle with circumstances where it would be appropriate onto an arterial road, considering the function that they provide. Sorry.
Yeah, I agree with that. I do actually struggle to foresee any circumstances where you would want to do and you would design that as your default position. But I suppose what I'm saying is it shouldn't be excluded. It should be allowed for with the appropriate assessment.
Okay. Moving on to your paragraph 16 of your evidence in chief, we talk about differences between discretionary and non-compliant status, and your default position that apart from a couple of rules there should be restricted discretionary activity. Wouldn't there be circumstances where there may be the requirement for somebody other than the applicant's traffic engineer and the council's traffic engineer to be able to put a view to on a particular application where there is that non-compliance? Got a range of non-compliances potentially there, or range of matters that need to be ticked off. Is it purely focused on traffic safety and capacity, or are there potentially other matters where somebody might choose to be involved in an application?
I think it would always relate back to, from my perspective, it would typically relate back to transport safety and efficiency. So I'm not really envisaging scenarios where other people would need to be involved. I suppose I would also anticipate that,
or other matters which may need to be considered.
I
You
mean,
know,
in
what it looks like, whether there's going to be any interference with any other accesses in close proximity, those sorts of things.
yeah, I can agree that if there's going to be an effect on other accesses that are in close proximity, that those matters need to be taken into account. I suppose, in my view, they relate to transport matters, though, and the concerns can be largely defined
Okay.
rather than being open-ended.
In paragraph 23 of your evidence, you talk about having a note about the existing level of traffic generation and preclude incremental increases in development that would avoid the rule. If you're looking at something which needs resource consent as being a high traffic generator, surely you would look at what is there at the moment and in terms of the existing traffic generation, in terms of the overall effects assessment from a traffic point of view.
You do need to, I suppose.
Because what you're suggesting here is you basically exclude existing effects. Okay, so you've got an access that might not be that flash, there might be a whole lot of traffic into and out of it, and you're adding something to that. So what you're saying here is you should exclude what's there at the moment, regardless of how good or bad that traffic situation might be.
I wouldn't say
from
exclude.
your assessment.
Sorry. In terms of the way that I'd intended this to work is to acknowledge that if you've got an activity at present that already breaches the high trip generator rule, I don't know, let's say it's a 60-child preschool for the sake of an example, and then if you're adding another 5 children to that, you're doing a full assessment. So you're obliged to do that full assessment rather than just sort of saying, well, it's only a small increase. So the actual increase in traffic associated with this isn't so significant that it warrants a reassessment. If you are then, if the increase that you're adding does trigger the high trip generator rule, then yes, you should be assessing all of the traffic, the existing plus the additional. So it's really looking to try and set a benchmark so that there's an acknowledgement of an existing level of traffic generation associated with an activity. If you're adding a small increase to that, sort of saying, well, is this really warranting a full assessment, or is it within a threshold that we think is tolerable? My opinion is that I think for small increases, it would be within a threshold that is by and large tolerable. Otherwise, small increases in any activity warrant quite a large assessment.
But your note basically says if you've got 50 kids at a childhood centre and you want to add 5 to them and it flicks it over, you can't take account of the traffic generation effects of the existing 50.
So, okay. So the intention.
So that's the way it says. For the level of trip generation, scale of activity for the site will not be included in that assessment.
Okay, so in terms of that, then perhaps the wording should relate to more when calculating the thresholds, not to include that existing level of traffic generation or floor area. When undertaking the assessment, yes, if an assessment is required, it should all be included, but not for the purposes of calculating the thresholds, is my opinion.
I'm wondering whether, for our benefit, you might be able to put what the wording of an additional note might be.
Yep.
If that's all right with you, Chair. Because on the face of it, I guess I'm a little bit concerned that you've got an existing use, for example, which has a reasonable amount of traffic generation into and out of it. It's never been assessed before because it's been there for a long time. You're now looking at something which is going to tip over into needing resource consent. And should you be able to look at the existing and the new, or just in terms of the new, when there's potentially the existing access or the existing location or something like that might not be good enough to meet acceptable traffic engineering standards.
Yep.
Okay. Para 28 of your evidence in chief. You talk about this, the high trip generator rules, and you'll be familiar. You obviously working across a number of plans, and this seems to be the way the transport chapters are being written now. With certain activities, you get to a certain threshold, they really need more than just the applicant's traffic engineer to look at it, and he needs somebody from usually the council to look at it, and potentially some other people as well. But can you just thinking about those other plans you've mentioned, QLDC and Christchurch as well, what is the main differences between the Selwyn plan and what they're providing? It seems to me there's a reasonable level of consistency.
Yeah, I think they are reasonably consistent. I think that putting, I suppose, Christchurch and Selwyn almost together, they set out a reasonable framework as to what they're expecting to be assessed. Auckland, Dunedin's got a similar rule, which has, I think, only 2 assessment matters, which are quite broad. I suppose my preference is I prefer the Selwyn Christchurch approach to the assessment matters in terms of being reasonably directive and setting out a comparable scale of assessment depending on the scale of development.
And the 50, 120 split between basic and full is pretty consistent practice.
Yeah, it is. I'll just have another.
Presumably that comes from various, research reports, Osroads research reports, and that, good practice methodologies for writing rules about what's, high trip generation and.
There is there's certainly a research report on the preparation of transport assessments. I can't recall what that included in terms of thresholds. I'm just no.
Yeah, it's a consistent theme in planning where you have a number.
Yeah,
it's a figure. It's sometimes called an arbitrary standard, but there's usually a bit of science in behind where you got to that number.
To be absolutely frank, in terms of the Christchurch numbers, they were come up by getting a group of transport engineers in a room and saying 60 vehicles an hour, that's 1 a minute. Does that feel significant? When it's sort of the consensus at that time was that was starting to get to a level where we would want to understand how the access operates, and then double that was getting to a number where we'd want to understand the wider effect. So it was agreed more on a consensus basis whilst doing the Christchurch city plan hearings.
Okay. And probably my last question, is my last question. When looking at the full transport chapter and the plan as notified, it's quite lengthy. There's a lot of material in it. There's a lot of diagrams. There's a lot of standards that need to be looked at. How would you find the workability from a traffic engineering perspective in terms of navigating through the 40 or 50 pages of rules compared to other plans you might have worked with as well?
I would agree. It seems quite lengthy in terms of, I feel there's looking at a rule and then sometimes looking at a requirement and then moving on and looking somewhere else. My preference is for, I suppose, attempting to consolidate as far as possible so that it's not a case of looking in one location to look at the next and look at a third. I don't have any issues with the overall content of it. But I would agree it's quite lengthy.
Okay. Right, thank you.
Yvette, any questions for Mr. Fuller?
No, thank you very much. They're well covered, the areas I was looking at. Thank you.
So, Mr. Fuller, I had similar concerns to Commissioner Dash about your paragraph 23 in your evidence in chief, which is repeated at paragraph 9 in your summary. And I appreciate that you've undertaken to give some further thought to some wording. Just when you do that, I'd also appreciate, Ms. Forrester, some legal commentary on that. To my way of thinking, I'm struggling to be persuaded how Mr. Fuller's proposal actually complies with the RMA in terms of effects, including cumulative effects. And if we were to take his proposal on board, in my mind, that would mean we wouldn't be taking into account cumulative effects, which of course would not be an appropriate course of action. So I just think it's fair to warn you that I'm struggling to be persuaded by this particular submission, and so give you the opportunity to persuade us, or me in particular. Thank you. But no further, one further question. So the top of your summary, top of page 3, you refer to the thresholds of 50 and 120 vehicles per hour. So the reporting officer has recommended an amendment to Tran Table 2, where the final row of that, have you got that in front of you?
I don't have the amendment.
Yep. Cool.
Table 2. That's it.
So it's around about page 22 of the appendix 1 to the officer's report, or appendix 2 to the officer's report.
So, yeah. Oh, yep. Yes.
Yep. So you see the very last row of that Tran Table 2, the officers recommended striking out some wording, which would leave just the 50 vehicles per peak hour and the 120 vehicles per peak hour in place.
Yes.
Is that what you are asking for, or were you asking for something different?
I mean, it's what I'm asking for in terms of 50 vehicles per peak hour and 120 vehicles per peak hour as being those thresholds. I'm satisfied with that.
So that meets your concern in that regard. So I can put a tick next to that.
It does. I think what this talks to, though, was within some of the other rules. I'm just going to have a quick look at my evidence in chief. So there was also, I think it was R4 and R8, which also have thresholds to do with the traffic generation permitted from activities. So Tran R4 has a limit there of 40 vehicle movements a day in the GREZ, and it's got a limit of 250 vehicle movements per day in the majority of other zones. So there's a requirement there to undertake an assessment of, I think for R4, there was a requirement to undertake an assessment of the siting of the vehicle access location and how it interacts with other accesses for a level of 250 vehicle movements a day, which is sort of another kind of quasi high trip generator rule within the plan. And correct.
So just before you move off that one, R4 or Tran R4, that requirement is quite specific to either the Rolleston Industrial Precinct or to shared access to sites which cumulatively generate that level. Does that change your view on that?
No.
And can you explain why?
Well, I suppose my concern remains the same, is that when doing development in that zone, in that precinct, there's a threshold there of 250 vehicles a day, requiring an assessment of an access that would otherwise be compliant. So it's of a compliant width, it's at a compliant location, it's got compliant visibility, it's got compliant separation to other accesses, and it's being, there's a need to undertake an assessment of the operation of that access. So 250 vehicle movements a day is something like broadly that would be an office that's 25 meters squared. So I think it's quite a small scale of activity to be reconsidering an access that already complies with the various district plan rules about its design and its formation and its location.
Okay.
My preference is to have a look at the peak hour traffic generation. We're looking at when an activity is in its busiest period and is it triggering those thresholds of the high trip generator rule.
And that would be the 50 and 120
That's right.
vehicles per hour. So you feel that would be a more appropriate threshold for that provision?
Yes.
Okay.
Let's see what it was. Oh, oh yes, so there is a similar requirement under TranRec 2, where I can see a reference to 100 equivalent car, well, 100 ECMV per day.
Can you just, what is it, ECMV? What's that?
ECM would be equivalent car movements.
Right.
I'm assuming that's equivalent car movements per day.
Yep, thanks. Not an electric car movement per day.
Oh, that was I'm aware that the wording of that was changed compared to the notified version that I was just looking at. I'm just trying to find where I found that in the officer's report.
Yeah. And the officer's recommendation to us, that particular one, Tran REQ2 is subclause C is retained at 100 ECMV per day.
Yes, and again, I think my concern there is that it relates to, again, what is quite a low volume of traffic to be undertaking that assessment of safety and efficiency, site access, vehicle crossing design and location, given that we've got, it's only 100 vehicles a day. So again, using my previous example of an office, that would be an office of 10 meters squared, at which point we are reconsidering whether the access is of an appropriate design and appropriate location, given that it's already got, in my example, it's got compliance with the district plan requirements around its siting, its width, its visibility, those sort of matters. Seems like a very low threshold to be asking for an assessment of that access arrangement.
All right, thank you very much. No further questions.
Good morning. Before I begin, there's a couple of minor corrections to my evidence, but it might be easiest if I draw attention to those because they're also in my summary. So when I get to them, I'll draw your attention to them. So in terms of my summary, my name is Jeremy Phillips. I'm a senior planner and a director practicing with Novo Group Limited in Christchurch. I've particular experience in urban land use development planning in Greater Christchurch and have a clear understanding of how current district plan provisions are applied and the implications on those contemplating development activities. I summarise the main points of my evidence in chief below. Trend P7 and Trend P13 seeking to minimise adverse effects. Minimise by definition requires one to reduce something, especially something bad, to the lowest possible level, which may not be necessary, practicable, desirable, or achievable, and or it may conflict with other objectives. Accordingly, these policies should instead seek to avoid significant adverse effects and manage other adverse effects, noting this would not detract from the intent of the provisions. I recommend the following amendments. In terms of Trend P7, the phrase avoid significant adverse effects and minimise other adverse effects proposed by the officer should be amended to read avoiding, and that's the first correction, which is in para 15.1 of my evidence in chief. So I should say avoiding significant adverse effects and managing other adverse effects. I believe that was a matter that the panel queried and the officer addressed in his addendum. And 5.2 of my summary, Trend P13, that the phrase minimise adverse effects by should be amended to read and delete the word minimise and replace with avoid significant adverse effects and otherwise manage the adverse effects by. And that equivalent change needs to occur in para 15.2 of my evidence in chief.
Unfurl the amendment again to the wording in your table document. So you were at 5.2.
Yep. So 5.2, strike out the word minimise.
It's in the second line.
In the second line.
Yep.
And add the word avoid with an underline. So I'm suggesting that the word minimise goes and the word avoid is inserted.
Great, thanks.
Paragraph 6. The matters of control or discretion that apply to most controlled and restricted discretionary activity rules relate to on-site transport effects or effects on the transportation network. As such matters will not directly affect other persons, non-notification clauses would be efficient, effective, and appropriate. By way of exception to this, non-notification clauses would not be appropriate for rules TranRec 2.7 and TranRec 21, given their broader scope, or for those rules concerning state highways or rail crossings where Waka Kotahi and Kiwi Rail may be relevant parties to applications. Given the specific focus of TranRec 1, Rec 2, Rec 4, Rec 7, Rec 16, Rec 18, and Rec 19, unfettered discretion is not necessary or justified, and therefore the activity status of these rules should be amended from non-complying or discretionary to restricted discretionary. I otherwise agree with the officer that Tran R1 and R2 should retain discretionary activity status given their broad scope. Tran Mat 1.7 considers any characteristics of a proposed activity or site that make compliance unnecessary and should be a relevant assessment matter for, and I'd strike out the remaining words in that line and replace with the words the rules listed in attachment 2 of Mr. Fuller's evidence. There's no change to my evidence in chief, that was just in my summary. So picking up in para 9, the absence of this assessment matter from rules may mean that other pragmatic considerations are not able to be considered within the scope of discretion, which is not efficient, effective, or appropriate. There is overlap and inconsistency between rules Tran R4, R8, and Rec 2, which all relate to high trip generating activities. Such rules can and should be consolidated with reliance on Tran R8 alone and its thresholds of 50 and 120 vehicles per hour for basic and full ITA respectively. Rule Tran R8 is generally appropriate, but it requires an exemption for the level of trip generation and scale of activity that existed prior to the plan becoming operative, to avoid the need for consent for small increases to existing activities, while still limiting the scope for incremental increases to activities and cumulative effects. And I'm happy to elaborate on that in the questioning. In para 12, a minor correction for rule Tran table 7 is required to ensure that the maximum legal width for a road is 25 metres rather than 15 metres, which is less than the required minimum. Thank you.
Thank you. We'll see if we have questions for you, Lindsay. We'll start again with you.
Just going off the summary, the first main point is Paris 5, 5.1, 5.2, presume it's not an inconsistent use of terminology here in terms of descriptions of how minimise or manage the use of effects. Presumably you've got a consistent view on this throughout the remainder of the plan.
Yes, that's correct. And I think I've raised the same point in earlier hearings, and we'll probably continue to do so. So I think the word minimise, where it appears, is a red flag because of the meaning that I've noted there. The alternative wording of avoiding significant and managing others, as I've said in my evidence in chief, I think it's an appropriate framework. Again, reference to the Christchurch district plan, that was wording that was employed for similar reasons.
What is the problem with the word minimise?
Well, minimise by
In terms of the dictionary definition.
well, it just
The smallest amount practical.
yeah. Well, the smallest amount practical may not be achievable, or it may not be necessary, or it may not be appropriate. Obviously, effects occur over a spectrum, and there can be, depending on the context of an application. So I think there needs to be sufficient flexibility in that wording to allow for that, rather than driving applicants to minimise effects.
And wouldn't the same apply to the word managing as well?
Not in my view. I think managing provides scope to minimise or mitigate or provide other ways of dealing with effects. So I think it's fair to say avoid significant effects. You don't want something that's going to have a significant problem, but for any other effects, you can take a measured approach that suits the context.
Okay, I'm sure we're going to hear plenty about that in future hearings as well. Your next one about non-notification clauses. I accept that for some things it should only really be between the council and the applicant, but there may be some other circumstances, as I've gone through with Mr. Fuller, where it might be appropriate, may well be appropriate, like there is an adjoining access owner or across the road access owner, which may, and you have something which is going to have significant traffic generation potentially. Do you think it's just between the council? Is there no circumstances where adjoining owners should actually be, or adjoining occupiers' views it may be appropriate to seek those views?
Look, I think it wouldn't be appropriate to say there'd be no circumstances where that's the case. I think in terms of the rules that have been identified, and I'm reliant on Mr. Fuller's evidence, that where there are traffic engineering matters that relate to safety and efficiency and network operation issues, they're a matter that can be resolved through an applicant and the council. The council still has the ability to consider the appropriateness or the scale of those effects, whether they're unacceptable. They still have the ability to actually consider whether the impacts on wider road users or other persons is still appropriate.
But it'd have to be through special circumstances, wouldn't it? If you've got a non-notification clause, the council, in order to be able to say seek the views of a third party, would have to say go down the special circumstances route.
I'm not suggesting that they would necessarily be notifying and involving other parties. I'm saying I think for those particular rules and with those assessment matters, the council and the decision maker can determine the acceptability of those effects without there being benefit or need for seeking views through a notification process.
Is your view that they should be, non-notification clauses should be used sparingly, or should they be widespread?
From a certainty and an efficiency perspective, I would say that they should be used where they can, what's more widespread. In saying that, from practical experience, unless all rules that an application is subject to those non-notification considerations, then I understand that they're effectively meaningless. So from, again, practical experience in Christchurch City, where they're used extensively, it's very rare for an application to have all of its rules subject to non-notification clauses and then have the benefit of that. What it does do, again, from a practical perspective, is it signals that certain rules, the focus is on site-related issues rather than issues that necessarily or are likely to affect other persons. So they're actually more for signalling that the nature of a non-compliance or a rule is not something that would typically affect other persons.
So in terms of those rules where you would apply a non-notification clause, there is no, in your view, nothing outside of the traffic engineering remit which would need to be considered. They're absolutely focused on
Well,
transport effects between the council and the applicant.
yes, with the exception of the rules that I've identified, so 2.7 and 21, which have broader scope. So I mean,
Well, you've got state highways in the mix as well.
Yeah. And
rail.
So with state highways and rail crossings, because you've effectively got another road controlling or rail controlling authority that has particular interests and information regarding the effects on that, certainly it's appropriate to involve those parties where that's relevant. Otherwise, if they're traffic engineering issues, again, I don't see a need for other third party or public involvement, except for those two rules that have that broader scope. So where wider amenity related effects might be relevant. That's less of a traffic issue. That might be a matter where you would want the scope to notify people if they're affected.
And the same line of reasoning goes into your recommendation that a number of rules go to restricted discretionary instead of discretionary, potentially non-complying as well.
Similar rationale again. If the matters if the rules are for a specific purpose, then there is no reason not to list that specific purpose and those specific considerations through assessment matters in a restricted discretionary process. It gives the council and the decision maker the scope to decline an application if they feel the effects warrant that. But it sharpens the focus, which I think is more efficient and effective than having broad discretion through a discretionary non-compliant status.
Okay. You heard both Commissioner Van Voorsthausen and my questions of Mr. Fuller around this, the issue of the exemption for, in your para 11 of your summary statement. Have you got any additional thing to comment in terms of that? Because to me, if you've got a site, there's already an existing level of traffic generation out of that site. There potentially could be existing safety issues. You have an incremental increase to it. You therefore shouldn't consider what's there at the moment, according to that provision. So, have you got any additional comment in relation to that?
So I think, firstly, the key thing is it's the distinction here about a threshold for triggering a rule, not establishing a level of effect that you can't consider when a consent's required. So I think in terms of cumulative effects, that's up for grabs as soon as a consent's required. I think the question here is where do you set the threshold and what's appropriate, and how do you balance not needing a resource consent for an activity, in the example that Mr. Fuller gave of two extra children or 5 extra children at a 60 child preschool, where that might be inefficient and ineffective and unnecessary, but then reconciling that with the example that you've pointed out where you might have some inherent safety issues. Ultimately, I think there's going to be a traffic engineering call as to whether there is a number or a level of traffic generation that can be tolerated even for existing access points.
Even if they're unsafe.
Well, it's a traffic engineering call.
You bank the existing activities is insane. You've got these existing activities. You're doing something which is going to be 10-20% increase in traffic volumes, which might trigger it over. So in terms of that statement, you shouldn't be able to take into account the existing activities in terms of that assessment.
No, that's for the purposes of the intent is, and I take your point that the wording might need revisiting, and that's fair enough. But I think that's where I'd stress that it's around the trigger rather than the assessment. But I think that there is a fair question. If you're not triggering a consent for an activity that's already got a poor safety situation, is that appropriate as an outcome in terms of allowing that activity not to need consent and further assessment until it generates an additional 50 vehicle movements per day. But I think that's a balancing exercise and a question for the traffic engineers as to where that's appropriate.
Okay, well, I'll look forward to seeing some revised wording. Okay, no further questions. Thank you.
I just following on from that non-notification and, looking at the trends, 2 and 7 and the concerns is I would just like to hear your views in terms of concern of non-consultation in terms of sites of significance and, the ability to be able to have input into that process. Can I just hear your views?
Sure.
In terms of, because like my colleague here, it's not sitting comfortably with me.
Sure.
The non-notification rules that you've got there.
Yeah.
Kia ora.
I think it's ultimately a balancing exercise, and you have to use those provisions, I think, judiciously. There's certain rules where it's quite clear that the nature of the rule concerns something, for example, on a site that won't affect other people. A common example that springs to mind is things like the provision of outdoor living space. If you don't meet a particular standard in that regard, it's not generally something that affects other people. It affects the site and the end users of that site. So there's no benefit in consulting other people on that issue because it won't affect them. Conversely, there might be issues that building heights where you could clearly start to impact on other people beyond the site. It's absolutely appropriate to allow for notification and consultation. For activities that aren't anticipated in a zone and you wouldn't expect to see there, again, they generally attract a broader activity status or scope to notify and consult other people. For traffic issues, that's where I think the judgment needs to come in terms of, do these particular rules benefit from, in terms of the issues that those rules are concerned with, is there a need or a benefit in consulting on those particular issues? Will other parties, if they're notified, bring something to the table and assist in better decisions or bring relevant information? If the issues that those rules relate to are traffic safety and efficiency issues, and they're ultimately a traffic engineering matter, then based on Mr. Fuller's evidence and my view, they're matters that the council can adequately deal with, and they're not going to be assisted with consultation on those particular rules. So I don't see that as a carte blanche, all rules should be non-notified. Absolutely not. It's these particular the rules and what their focus is. Thank you.
And Mr. Phillips, no further questions from me, but just a comment. There's been a lot of submissions made to us already about the use of the word minimise, particularly from what I might call developer type submitters, and we understand the concern from their perspective. Certainly our evolving understanding of the word minimise based on the dictionary definition is that it means reduced to the smallest extent reasonably practicable. There's also a countervailing view, which I've put to a number of submitters, that the word manage is meaningless because every time we consider a resource consent application as a decision maker, your aim is to manage that. It doesn't provide any outcome oriented guidance whatsoever to a decision maker. So, I mean, we'll be giving this issue some further thought, but just wanted to remind you that there are two views on the word minimise and manage.
Right, thank you.
But thanks very much for coming in this morning. So the next submitter on our list is Midland Port and Littleton Port Company Limited. I think you've arrived, so we're going to have a 5-minute break while you arrange yourselves at the submitter table, and then we'll resume the hearing shortly. Thank you.
Nicole Reid, Selwyn District Councillor, Commissioner.
Lindsay Dace, Planner, Independent Hearing Commissioner from Wellington.
Tēnā koutou katoa, Yvette Couch-Lewis, and Independent Hearings Officer for iwi. Kia ora.
Right, over to you.
Tēnā koutou katoa. I'm here, Amy Hill from Chapman Tripp, and with Mr. Bonus and Mr. Metherell on behalf of Littleton Port Company. And we did not file any legal submissions, so just to quickly orient the panel, because neither witness has prepared a summary, happy to get straight into questions. There were a very narrow range of issues still live for LPC following the Section 42A report. Mr. Bonus has outlined where he has agreed with the Section 42A officer recommendations with respect to LPC's relief on policies 3, 7, and 8. And so I think we're here today really to discuss the high trip generator rule. So we're staying on that, following on this from the discussion with the previous submitter. And I think perhaps we'll start with Mr. Metherell and then Mr. Bonus can wrap up with the planning.
All right, thanks very much for that. So, Mr. Mether, I understand you haven't prepared a written summary, but are there any key points you'd like to highlight to us verbally, or are you happy to go straight to questions?
I'm happy to go into questions today, thanks.
Excellent. Lindsay.
Just a couple. Your evidence in chief 9.4. And it's detail maybe other answers as well. But in terms of volume of goods at the inland port, which goes to Littleton, what sort of percentages are we talking about in terms of the tonnage that gets dealt with in the port company? Sorry, the inland port compared to product which goes directly to the port from elsewhere.
I actually haven't got that
No,
detail.
and
Sorry, yeah.
possibly
Yeah.
would be unfair. Sorry, I keep on forgetting to turn that on. Beg your pardon.
We do have someone from the port company, but we'll have to check and confirm. Would that be helpful to just put that in an email?
It's not a significant issue. It's just out of interest.
Yeah.
Just, what proportion of the goods goes through the inland port that goes out of or into and out of the Port of Littleton.
Yeah, I can't provide that offhand, but
I just really want to feel whether it's 5%, 10%.
Yeah. My understanding, without being able to give you a number, is that some of the previous evidence from Port Company and other hearings has covered some of that detail. The main bit there, it'll be by container volume. So Midland is container, whereas the port itself has other exports that would relate to the same thing that goes through Midland, including logs, coal, etc. So it'll be the container volume proportion that we could
Okay.
to that number.
Oh, that's interesting. Thank you. I guess you've heard the previous discussions with the previous submitters about this whole thing about lawfully established development and whether you can include them in, whether you should include them in high traffic generators. When consent is required for those. Have you what's your comment on what we've heard previously?
So I only caught the very end of that presentation. Sorry, but
I guess the position that was put to us was, if you have an existing development and you're going to propose something which is going to require resource consent because it then flicks into being a high trip generator, should you consider the safety or traffic generation effects of what's there at the moment in terms of the overall assessment of whether or not a proposal was acceptable?
so in my experience, it'd be a case of if first of all there's a trigger as to what level of development you might have to do a particular assessment for, and usually if that trigger was met, then we would take into account the existing context. And so in, I guess, combination with a range of other transport rules in the district plan, so the likes of vehicle access, locations, car parking requirements, all of those other ones sort of intertwine. And so if you're above that threshold requiring an assessment, then yes, would be taken into consideration how that existing network works. If it was less than that threshold, then there's still rules that may be triggered. So I think I heard you say if there's an unsafe situation. So that might be because of, for example, an access that has been in the past poorly located. So the district plan, as notified, includes other rules which would capture that. And so we'd be looking to sort of, you'd still have to do an assessment there if there was something of significance.
So you would have to include an assessment. In an unsafe situation, you would have to include an assessment of why it's unsafe, and it's only the additional matters. Well, I'm really just trying to get some clarity, and it comes up in Mr. Bonus's evidence as well, this exact same issue. And when I saw it, I thought, okay, I can sort of understand, but then again, I don't understand, because you have a situation where you potentially got a builder's yard, for example. It's been going for 50 years, and they decide that they potentially might want to put some more retail or something on that particular site. And because of that retail component to it, it triggers a rule assessment. But if the site's already unsafe, it's already got a whole lot of traffic movements which are significant, but they've been there for a long time, you can't necessarily, or you shouldn't, in terms of the wording that's being proposed, take into account the existing effects.
That's right. If your level of development that you're adding to that was less than the threshold that's been put forward. So I think the proposition from Littleton Port Company is that the thresholds would relate to additional development or new development. And if you go above that level, then you'd have to take account of how that network operates. So if you're using a similar access, then you'd then have to be dealing with that level of traffic generation and considering sort of the safety impacts. Otherwise, if that yard was below that threshold, then the question would be, is there another rule that would pick up that existing safety issue? For example, it would probably most likely relate to something to do with its access position or form. And so the rules have provisions around things like separation from intersections and that. So there will be one or two where it may not be captured, but I guess in terms of the sort of expectation to have to do an assessment every time, that would be, it's quite an onerous sort of task. So I think when we had that sort of discussion for Christchurch district plan, it included that recognition of existing before you go to consider your threshold. And that was simply trying to make administration of the consenting process more efficient, so that you didn't have to come to a traffic engineer every time you did something very small, I guess. But I think your primary concern that would existing issues get considered if there's a larger development being added onto it. We, as a traffic engineer or as a professional, I would, in most cases, when I've reviewed other applications, would expect others to consider any existing issues as well.
Well, the wording that's being put to us doesn't do that, though. That you should be able, you potentially will disregard the effects which exist.
Well, I think you'd be looking at the assessment matters under the high trip generation rule, and so my understanding is that would give the scope for someone to look at that level of detail, but you have to trigger a threshold first. I mean, there may be a whole range of reasons why, for example, an access is unsafe. In an existing situation, it may have nothing to do with the development site itself. It might just be simply that traffic volumes have grown over time, but that's also taken into account through things like zoning provisions.
Or perhaps it's categorisation on the road hierarchy's changed as well.
Yep.
As being a relevant issue.
Yeah. So if you're adding development, for example, I guess across the road to the council building, this environment's changed a lot since then. And the road hierarchy has probably changed as well, but the district plan rules outside of the high trip generator rule have sort of road specific provisions around access. And my understanding is that they still have to be considered. So if you're putting additional development and it's accessed through an existing vehicle crossing, that would still be a trigger. Well, that's how I've usually applied a district plan standard.
But it may not be a trigger if you're disregarding what's there at the moment.
If it was compliant with the other district plan rules, then it wouldn't be a trigger.
But if it was existing and it was non-compliant, would you need to consider it through the rules?
Yeah, and so there's the rules around vehicle access would then have assessment matters which would drop you down to consider vehicle, safety at that vehicle access and the performance of that. So it may not, and because the high drip generator rules trying to look at, in my sort of experience, is looking at larger developments and potential network effects, whereas the vehicle crossing rules would be picking up the local safety issues as a primary sort of part of it anyway.
Okay, we might hear some more on that later. Okay, and I'll put to you the question that I asked Mr. Fuller as well. Transport chapter is very long, very detailed. There's a number of matters in there which need to be ticked off. From a traffic engineering perspective, who writes TIAs, etc., those sorts of things, are they workable overall? Are they consistent with current best practice?
So, and I've only, just to clarify, I've only been asked to consider this chapter on the submission points by LPC. Through my sort of, I guess, looking at the other matters, at a first glance at least, it looks like it's a standard sort of district plan provisions. It's got the sort of rules that I'd expect to see there. Every district plan has its little fish hooks that get picked up at some point. And for example, my understanding is like the Christchurch one's going through a bit of an evolution that was only done 5 years ago because there's rules that weren't quite right.
Okay, thank you.
I should turn that on. No further questions from me, but in terms of that issue of the high trip generating activities, it's obviously a matter that's of interest to us. And Mr. Bonus, I was going to ask you about that because you raised that in your evidence as well, your paragraph 22, but I won't ask you a question about that. I think the issue is well understood. Certainly my concern is I simply don't understand why you would disregard the existing traffic movements from a site if an additional development causes that to trip over a threshold. In terms of cumulative effects, I'm struggling to understand why you would disregard all of the traffic from the site. So we've invited Mr. Fuller and Mr. Phillips who appeared for the Carter Group to think of some alternative wording. And I invited Ms. Forrester, who's legal counsel for that submitted, to provide some kind of legal argument as to why that's appropriate from a cumulative effects perspective. So to you, Ms. Hill, I'll ask you to do the same. And if you could sit down and talk with Ms Forrester so we get one legal view from the submitters asking for this type of relief, that would be helpful. Yeah, and Mr Metherell and Mr Bonus, if you're happy to sit down with Mr Fuller and Mr Phillips and put your heads together and try and come up with some wording that addresses our concerns, then we'd certainly appreciate that. But no further questions from me in that regard. I presume your snowboarding days are over, are they?
Thank you for asking, sir. For a little while at least.
Nasty injury by the looks of it.
It was, and I do wish to acknowledge and my appreciation for the panel in terms of accommodating me
Oh, more than happy.
in that particular way.
From someone who blew his knee out skiing 5 years ago and was on crutches for 3 months, I sympathise.
I was lucky enough that Mr Willis, who was on the panel, was actually up at the mountain at the same time. So otherwise, presumably, I would have had to have provided a doctor note and an X-ray as well.
Yeah, we heard about that. So sorry, I've kind of disrupted the flow of your presentation. So, Ms Hill, I assume we will now hear from Mr Bonus. Is there anything you want to say by way of summary, or are you happy to go straight to questions?
No, I think I can go straight to question. The only point that I would make is, by and large, the expert opinion from, or expert advice from myself and Mr Metherell is largely in agreement with the Section 42A reporting report. And I would also agree with Mr Metherell's point made earlier that the provisions, and whilst I've focused on the submissions from LPC, the provisions themselves put together by the council, including, I understand, ABLE, by and large provide a comprehensive and fairly orthodox approach to sort of managing transport. There's always fishhooks. That's the nature of plan drafting, and we do our best through these exercises to try and identify what they are. I'd also make the point that perhaps in a coding moment, when I drafted paragraph 22, I deleted reference to excluding consideration of an ITA for granted consent. But I think this goes back to the panel's concern as to the purpose of the rule and the evidence from myself and Mr Metherell as to why we would exclude those. And I take the panel's point that we will go away and look at that and come back with further advice. But I think the point that I would like to make, and I'll make it very, very briefly, is what is the purpose of the high traffic generation rule and what are we trying to achieve with it? When we set a zoning framework, there's a very broad level transport assessment done in terms of modelling as to what are the zones that are identified and what is the traffic flows on those, and can the network generally cope with it. There is also a series of provisions as to, as Mr Metherell's identified, queuing space, access. Those provisions will kick in regardless of whether or not there's an incremental change or otherwise in terms of an activity itself. The last point that I would make to the panel is that for a lot of high trip generating activities, whilst the high trip generating rule is explicit around those, whether or not we include the threshold for pre-existing activities, a lot of the things that we would be worried about will be picked up by the status anyway in particular zones. So, for example, sir, your example of retail activity in a yard supplying business, presumably that would be in the general industrial zone. That incremental increase would actually be picked up by the status of what that activity is. That would be discretionary and non-complying. That allows a whole wide range of the ability to assess particular effects, including transport effects. And I think that's what Mr Metherell was referring to when he said, look, if I got something like this on my desk, of course I'd look at the existing environment and see whether or not that is. So the point of the suggestion here is really around fine-tuning the purpose of what this rule is about, what it is trying to resolve and deal with in an efficient and effective way. And I think what Mr Metherell and I have suggested is, based on our experience in Auckland and Christchurch, there could be a bit more clarity as to where that threshold kicks in and where you exclude existing activity, because I think the recommendation from us both is that there are enough tools and there are enough mechanisms in the plan to deal with existing safety and efficiency issues. So I'll park that there, but that's really the basis of it, and I look forward to working with the other experts in terms of providing something a bit more coherent.
Thank you. Thank you for that. And Ms Hill, I forgot to speak to Ms Forrester about timeframes, but we receive a reply report from the officers generally 2 weeks after the conclusion of the hearing, so 2 weeks from now. So it'd be really useful to get that further work, probably say within a week from now, so then the officers can have regard to it when they give us their final advice. So if you can liaise with her, and if a time frame of around about a week is suitable, then that would be grand.
Yes, so that sounds fine.
Thank
The
you.
other thing that just crossed my mind is Mr. Metherell has made reference to the rules that are in various other district plan documents. Are you interested in an elaboration on?
No, I think if we
those
were
or
interested,
happy
we
with-
would have asked them about that. So.
Right.
All right, but I'll just see, Mr. Bonus, if we have any further questions for you. Lindsay, any questions for Mr. Bonus?
No, I think Mr. Bonus has given an explanation of his position. But perhaps if I can just follow up with one thing. If you had, going back to the yard-based scenario, which potentially has retail, if it was yard-based and the additional matter was permitted in that zone, and we were just focusing on this one rule, would that make any difference when you're just completely looking at high trip generating activities, particularly if you're looking at a potentially unsafe scenario, you've got an existing unsafe scenario?
It's probably a planning and legal question as to looking at, if you've got, for example, a non-compliant access point, and that fundamentally will be the localized issue of concern. And without having the actual example in front of me, I would suggest that there is an avenue for the council to say, well, look, given the increase in traffic flow from what you're proposing around floor space, we're able to revisit the access rule. It's non-compliant. We would like an assessment based on that. And then it would come down to whether or not those assessment matters were broad enough to actually deal with the other safety issues. And I haven't looked that far. But I would suggest that there is an avenue. But again, the number or frequency of the concerns that we have is quite small. And I guess what I'm suggesting, or what Mr. Metherell and I are suggesting, is what is the purpose of the rule in the broad spectrum of the overall plan provisions, and is it inefficient in terms of the way it's currently drafted, and in terms of the nature of the issues that could arise. That's all we're pointing to.
So you think in most scenarios, it's going to get picked up by consent being required under other rules, which will put it potentially to discretionary anyway.
In terms of the activity status, quite possibly, but in terms of the mechanics around the transport rules for access and egress and queuing and everything else, it may well get picked up by those at that minute level, regardless.
Okay, thank you.
Yvette, any further questions for Mr. Bonus and Nicole? No, I think that pretty much covers what we wanted to ask you about. So thank you very much for coming in, and we look forward to the further material that you're going to assist us with.
Thank you, sir.
Thank you.
Thank you.
So the next submitter on our schedule is Kainga Ora, and they're going to come to us by Zoom, hopefully.
Can you hear us, Ruth? Can you hear us, Ruth?
Yes,
Sweet.
cool.
So,
Good morning.
Yes, good morning and welcome. It's good that you can hear us and we can see and hear you. So we have received your pre-circulated written material, legal submissions and 2 briefs of evidence. Thank you very much for providing that. You don't need to read that out loud to us, but you're very welcome for each of the authors to highlight key points for us, or else we can just go straight to questions, but we'll pretty much hand that over to you.
Thank you. I think Mr. Collins is going to start next up.
Yeah, thanks, Ruth. Look, Commissioners, I'm happy to go straight to questions if you're happy with that.
Yep, we're certainly happy with that. And Lindsay, again, we'll start with you.
Guess I really just want to start off with this lot numbers on private access ways. You're recommending that it increase from 6 to 10, I think. What's, isn't there also some sort of rationale for the 6 in terms of adoption of an access way as a public road? Don't a lot of councils say, well, if you're having more 6 lots off an access, you therefore want to adopt that access as a public road because there's got to be various different public services vested as well. Isn't that a justification?
Absolutely, Commissioner Dash. And my experience in regards to transport aspects of it, I appreciate there may be some other aspects around services, utility services, etc. But yeah, look, in my view, the transport matters are around absolutely connectivity of the transport network. And I think, you know, that's been highlighted in the Section 42A report as one of the concerns about having a higher number of lots. I guess I have looked at, you know, in my evidence, I've addressed district plans that I'm familiar with, and there is a range of thresholds that various councils have used, you know, sort of 6, 7, 8, 9 through to 10 lots as a permitted activity. And that's what I base my evidence on. In my view, that the above 10 is certainly where you would start wanting to look at public vesting in terms of connectivity of the road network. Certainly, if you had large scale use of private access ways, that absolutely does affect the connectivity permeability of your network, particularly for pedestrians and cyclists, where you're essentially creating much longer journeys for them.
Isn't there also some sort of cut-off, an arbitrary standard which applies to access way width and formation as well? And where should that trigger be, with 6 lots or 10 lots? And I think there's a lot of different district plans have a slight variation on it, but generally, the more lots you have, the wider it needs to be. There's potential for needing to potentially look at a footpath, the more access that there is off there. If it's 1 or 2 lots, you know, people can wait if they need to, if there's insufficient width. What's the industry standard in terms of what the cutoff is for going to a higher standard of road formation?
Yeah, I absolutely agree in terms of the design of private access ways. And in Appendix 1 of my evidence, I just included some suggested changes to Trend Schedule 1 access ways, so Table 3, where I've added another line item or row in to address lots. Access ways that have 7 to 10 lots. So for that, I'm certainly putting forward that would be two-way vehicle access. The legal width of 6.5 metres, which allows provision of a 1 metre footpath and a 5.5 metre carriageway, so that absolutely, the more residential, or the more lots that you have accessing there, the more vehicle trips that you're creating, the greater potential for conflicting inbound and outbound movements, which is why a single width access way sort of for 3.5, 4.5 metres, I don't think would be appropriate for the higher lot numbers.
Okay. No, I think that's it for me. Thank you for that.
Nicole, any questions for Mr. Collins?
Yeah, I just want to tease out what Commissioner Dash has been talking about. So essentially, you're proposing almost to double what is the limit that is being proposed by council. And from the Aberley report, they've already got issues, presumably with with people with these access ways, which is why they've restricted to the 6. So I still don't clearly understand how it's going to be mitigated by going bigger. So you're proposed in your table, so a different carriageway width, but with that number of properties, isn't that suitable for a street? I'm just a bit confused as to what the thinking is for you guys behind. I mean, just thinking about effects, transport effects. There's a big difference between just having an access way and having a street.
Yeah, thank you, councillor. It's, I guess, using the argument between a private access way versus a public road. In my view, there is no hard and fast sort of cutoff as to where it's appropriate, where it's not appropriate. In my view, having 10 lots accessing a private access way is acceptable. What you tend to get with, if you set that threshold too low to switch over to public road, you can restrict development opportunity by, because council obviously has minimum road width requirements and things like that. You can set that sort of threshold too low that you can stymie development, particularly where you have panhandle development, where you have lots that are remote from a road and they're using an existing right of way. Often those right of ways aren't wide enough to vest as a public road. And conversely, if you set that threshold too high by enabling too many lots to access a private right of way before you have to vest, then you start triggering some of those other issues around connectivity of the public network. You get issues around waste collection, some of the other issues that I've highlighted in my evidence and what Everly have highlighted in their technical report. What I've seen in practice around the use of private access ways, that has been Auckland, Hamilton, some in other parts of Waikato and Northland, is that 10 lots on a private access way is not an unreasonable outcome. It's not one that is difficult for council to manage. And what I've found is that in some instances, some councils are happy for a greater amount of lots to access a private access way because it reduces the council's asset base by not having to vest additional road that isn't, I guess, a key part of the network, and that it's and potentially less appropriate and less of an issue in Selwyn, where there aren't so many physical constraints on a site. But certainly, for example, in Auckland, where you might have a wetland or a ridge line or something that bounds the property, there's not much value investing it as a road. So I might be rambling a little bit here, but I guess what I'm saying is that there is certainly disbenefits for setting that threshold too low, and also disbenefits for setting that threshold too high. In my view, 10 lots is pretty consistent with other district plans around the country, and from what I've seen through subdivision consents and land use consents, that is an appropriate level.
Okay, thank you.
Yvette, any questions? So, Mr. Collins, just one very small issue from me. Your Appendix 1, have you got that in front of you?
I do.
So just, you see there the wording in red where it's crossed out in the left-hand column, the clause that starts with 15, and then you've got in the right-hand column a clause starting with 15. Should that reference be to REQ 7.14? You've written it as 0.12, was it?
That should be as per the section 42A report. So I have potentially, I have potentially copied that across incorrectly. I'm just having a look at the section 42A report. I'll check that, Commissioner, and come back to you.
Yep, thank you for that. No further questions of clarification. What you're asking for is clearly set out in your evidence, and I look forward to getting the reporting officer's response to that in due course in their reply report. Thank you. So Ms. Evans, back to you.
Thank you, Commissioners. I'm happy just to take questions unless you'd like me to read out a summary.
No, I think we can go straight to questions. And Lindsay, we'll start with you again.
Morning, Ms. Evans. Your paragraph 7.4. Yeah.
Yes.
Okay, so it's talking about the wording of policy, and you are recommending adding the word so as to avoid mitigating remedies adverse effects on people and the environment. That's your position. What does that actually add to the policy? Because it's an enabling policy, and it does have the words while managing scale and types of works. So what value does the additional wording actually add to that policy?
I think in the instances where where you didn't comply with one of the rules that the policy is guiding, it gives you an outcome to focus on. And I agree it's an enabling policy, but it would provide more certainty that whilst doing those enabling activities, there is a requirement to avoid, remedy and mitigate effects. And that would be proportionate, I guess, to the proposal and the effect where there was a non-compliance with a rule.
But isn't that implicit in the policy, right? It's good. You know, there have been some discussion around the words managing. So managing the scale and types of works of activity. I guess I'm just struggling with what does that actually add? The whole, it's ingrained in the Act that you need to avoid, mitigate, remedy adverse effects on people and the environment.
Yeah, except that it's certainly ingrained in the Act. I think, we do see policies which have a direction as to what you do when there are adverse effects. And I guess sometimes the scale and type of activity occurring within the transport corridor could have adverse effects, and this gives you an outcome by where you manage those. And I think manage in that respect would probably encompass the broad spectrum of avoid, remedy or mitigate.
Okay. Put my microphone on, which I should have been doing anyway. Apologies for that. One more question in terms of, it's mainly your paragraph 8.3 when you're talking about notification provisions. Were you online to hear any of the previous discussion with the previous submitters?
Yes, we heard I wasn't right there at the start, but I did hear the questioning of Mr. Phillips.
Okay.
And his expert.
Yeah, I guess it's a slightly different issue to what we were talking about with Mr. Phillips, but really is whether or not there needs to be a non-notification provision relating to transport, whether there are circumstances where there needs to be another party apart from the council and the applicant involved in the assessment. Your statement in the latter part of 8.3, in assessing infringements to transport rules and rule requirements that relate to residential development, the council is unlikely to obtain any through notification, and these activities are anticipated. Can you just expand on what you actually mean there?
So, and we're focusing here on residential activities, and I guess only in relation to the rules and rule requirements listed in the next paragraph 8.4. But I guess what I'm suggesting here is that in my view, in relation to those rules, the effects can be assessed by the applicant and by the council and any, the report, the decision maker and any expert traffic engineer as to what the effects would be. And I'm suggesting that there would be nothing more in most cases to gain by a limited or public notification process. I think we're talking about rules where there wouldn't be any adverse effects anticipated on say other persons neighbouring to the site that couldn't be foreseen by the council.
Yes, are there any circumstances where there might be a perverse outcome, that there is an effect upon somebody else apart from the council in relation to those like vehicle access ways? You've potentially got a next door neighbour who has quite a close vehicle access way to it. Now, they can't do anything about that, but they might be seen to be affected if there's an increase in traffic volumes and the typology of traffic. Would it not be appropriate in certain circumstances for them to be considered an affected party?
I think that the council in that example that you'd given could make that assessment without needing any additional information from the neighbour.
But if there's a non-notification clause, it would have to be on exceptional circumstances basis that council would take that action.
To notify, yes, it would be under special circumstances if the decision was made that there needed to be limited notification. But in relation to these examples, in my view, the applicant and certainly the council and the council's expert traffic engineer would be able to assess those effects associated with perhaps a nearby adjoining access.
Okay, thank you.
Are there any questions? No, Nicole, any questions? Just two follow-up questions on the issues that Commissioner Daish has discussed with you. So taking you back to your paragraph 7.2.
Yes.
And the discussion that avoid, remedy, mitigate just parrots what the Act already obliges all decision makers to do anyway. What would be your response to a suggestion that instead of avoid, remedy, or avoid, mitigate, or remedy, that we would say so as to minimise adverse effects on people and the environment?
I have heard the discussion previously that you've had in relation to the word minimise. I hold a similar view to Mr. Phillips in that minimise, if you take the dictionary wording, is to reduce to the lowest extent possible, although I think you may have said that it was practicable earlier. So in those instances, I think it's preferable to say avoid, remedy or mitigate, because that allows you to consider the effects proportionate to the proposal, and in some instances it may not be necessary to minimise those effects to the lowest extent. Perhaps you could consider reducing or mitigating them. That just provides a bit more flexibility, in my view.
Okay. And yeah, the wording in terms of if we were to use the word minimise and have a definition of it in the plan, the type of wording that we might settle on would be reduced to the smallest extent reasonably practicable. So does that alter your opinion at all?
I'm still of the view that providing the other options, avoiding or mitigating or remedying, is more appropriate. I'm just trying to think of the circumstances in which minimise may not be able to be met. I guess in relation to what this policy anticipates, it could be appropriate. I think my preference is still to have the broader range of options,
yeah,
particularly for an enabling policy.
Yeah. All right, and in terms of your paragraph 8.4 on the issue of non-notification clauses, which Commissioner Daish discussed with you, I think it's only fair that I put to you that I'm not persuaded by the arguments that we should provide for non-notification, given that the Act has a robust process for determining on a case-by-case basis under Section 95, etc., whether or not notification should occur. So I guess I'd just extend to you one final opportunity to try and persuade me in that regard. I undertake a number of Section 95 analyses as an independent hearings commissioner for councils all around New Zealand. It's a robust process. It results in reasonable outcomes in each case that are specific to the case. So persuade me.
I think in my view, as someone who I guess writes AEs and has also previously processed applications on behalf of council, it does help with effective plan administration and application to have those non-notification clauses, and only where it's where the effects are confined and can be easily assessed by the applicant and also council's assessment team and expert. Where they're unlikely to directly affect other persons. I think it's a plan efficiency advantage from my perspective, and I think that they're helpful where they are used elsewhere.
So if we were to insert a non-notification clause, would we need to be comfortable that there was almost 100% likelihood that we would never, in any circumstances, think it appropriate to notify an affected party or the public generally?
It'll be hard to satisfy yourselves that you're nearly 100% certain. I accept that there may be cases or anomalies where there is something that could be added by perhaps a neighbour to guide council's assessment. But I think as long as it's confined to those matters where the effects are easily able to be assessed by the council, I don't think it's necessary to have the opportunity to notify.
So do the views of lay people in terms of the effects of activities on them quite often usefully inform expert opinion and reviews?
Yes, they certainly do. I think if there was, there could be instances where the council knows that there's an issue that has been informed by lay people, and that could certainly be taken into account, particularly in a local context. And that's why you have to be careful about the rules where you do suggest a non-notification clause.
All right, great. All right, well, thank you very much.
Thank you for your time.
Thank you. Good morning and welcome to Wakakotohi NZTA. Thank you very much for coming in. I think you have appeared before us before, so you know the drill. Thank you for pre-circulating your evidence, which we've read. You don't need to read that out loud to us, but either of you are welcome to highlight verbally key points that you'd like us to bear in mind, or if it's your preference, we can just go straight to questions, but it's very much over to you.
Thank you. I'll start with introducing myself. So I'm Sarah White and I'm employed as a planner at Wakatahi. And this is my colleague Stuart Fletcher, who is employed as a principal planner at Wakatahi. And Mr. Fletcher has accompanied me today to assist in answering any questions you may have. Just to highlight, I won't go over a summary of my evidence, but just to highlight key points. I'd like to note that the majority of the issues raised within the Wakatahi submission have been resolved, and there is general support for the recommendations in the Section 42A report. My evidence does identify a few remaining suggested changes in terms of wording of some of the provisions, but I would like to draw attention to the key issue that I see, which is regarding the requirement to obtain resource consent for access to the state highway. And I believe that this would be better suited to be moved from the rule requirements section of the chapter up into the rules section of the chapter. And I'm happy to take questions now.
Can you just remind us what provisions that related to specifically?
That is rule requirement 4.
Yep. Yep. All right, and Mr. Fletcher, did you wish to add anything at this stage?
Not overly. The reason we talk about shifting that rule requirement is that people will read through the plan and they will say, oh yes, I comply with that, meet this. And then there's this sort of, you might call it an umbrella provision, which says actually you're connecting to a state highway, you need resource consent. So it seems more logical just to shift that up the front. So from the outset, you know you need resource consent.
All right, now thank you very much for that. We'll see if we have questions for you, and Lindsay, start with you again.
Just on that last point, I have to say in a former life, I used to work for the former NZTA Transit in the Wellington region, some 15, 16 years ago now, so it was fairly dated. But isn't there also an additional level of control that the agency has over accessway formation to state highways, particularly limited access roads? Isn't there potentially a duplication of within the district plan and your own requirements under the Government Roading Powers Act?
You are correct that there is the LAR provisions under the Government Roading Powers Act, but not all state highways are limited access roads. So there is that alternative pathway. In terms of the physical construction, there's also a separate process in terms of a corridor access request to undertake works within the state highway, but we do rely on district plan provisions across a lot of districts and regions in New Zealand.
Okay. Just for my own interest, what parts of your network in the Selwyn district aren't limited access road? Presumably your urban areas, your 50k areas. Are there any others that you haven't got LAR protection of some kind?
I would need to confirm that.
It's not a biggie. I you know, many years ago, I think there was a very big drive to get all rural state highways to be limited access roads.
I would suggest quite a reasonable proportion of state highways in the Selwyn district would not be limited access roads. It's very popular in the North Island to have LAR provisions, but it's slightly more random, you might say, in the South Island. We've certainly can produce maps to identify the areas, but yeah, there'll be quite a large proportion of the state highways that are not LAR. Every option has headaches as well, including LAR.
Yeah, okay. That be that as it's may, I think your point's well made that you know, state highways are right at the apex of the road hierarchy, and attention needs to be given by the road controlling authority in terms of access location, access design, and so forth at the appropriate time. So what you're suggesting is getting a little bit more upfront when you go through the rules. You actually say, well, I'm on a state highway, therefore there is a process which I need to go through. So that's fine. Just looking at the rest of your evidence, Ms. Evans.
Ms. White.
Oh, Ms. White. We had Ms. Evans before.
We did.
Beg your pardon. You would have heard the discussion about non-notification clauses before, your paragraph 4.3, 4.4, etc. What's your view on what you've heard this morning about the necessity for non-notification clauses relating to transport rules?
I agree with the discussion that was previously just had with Ms Evans regarding whether you can be 100% sure, and that there needs to be a consideration of effects that would be a very situation specific to include a non-notification clause.
Okay. My next one is in relation to your para 7.3. And again, it goes on from the discussion you've probably heard about managing versus mitigating or potentially minimising adverse effects. So mitigation is one tool. You've got avoid, you've got remedy, and you've got mitigate. Whereas managing means, in this context, potentially the wider range of options than just being able to mitigate that adverse effect. You got any comment on that approach?
The focus on my evidence is really looking at the use of the term avoid, which was proposed as part of the 42A recommendations, and whether that was appropriate to be avoiding significant adverse effects while minimising it, and just sort of clarification around that and confusion and the use of the term avoid. But I think mitigating is probably more appropriate than managing or minimising.
Yeah, if you look at the rest of that, you've got, it's all about reducing safe and efficient traffic flows, strategic transport network and links with Christchurch City. That's what it says at the moment. So mitigating doesn't mean in certain circumstances you should avoid. It's very discrete. It's about you're producing an effect and you're going to be mitigating that. You're going to be doing something to make it better than it was. So isn't that a bit limiting to that particular policy, just having mitigating?
Yes, you could say that.
Okay, thank you.
If I can add my 2 cents.
Sure.
If you don't mind. One of our concerns was more around the term avoid, in that councils seem to be placing more and more weight on the use of the term avoid. And so I struck a policy in Christchurch which said avoid commercial and industrial activities in rural zones. And that was pretty solid, and the council just said decline because of that one policy. And so where it becomes more important is if you're going to say something like avoid adverse effects unless they can be, addressed or whatever. It's using the term avoid in a different manner, and to me you want to keep that term avoid and use it when you want to make your heavy hits, you might say. And so that's sort of part of the reasoning behind that. So even if you incorporate the term avoid, remedy and mitigate, are you starting to lose some of that strength of term that you may want to keep for some of your other policies to drill it home, you might say?
I guess, and you heard the basis of that discussion. With the word mitigating, it doesn't really give you the avoid option. If you can, if there are significant adverse effects, and they really should be avoided, you just don't want to go there. Mitigating assumes that there will be some effects, but you can do something about them.
Certainly. But yeah, if your intention is that there should be no adverse effects, should you be using the term avoid, and that is all? It's sort of that balancing act.
Okay. Well, we'll leave that one for now. Sorry, I'm going off multiple screens here. Your para 9.3, where you're wanting to put in an advisory note which basically says, well, these things don't apply when you've got a designation on a list listed in this district plan. Is that a common process to actually put that exclusion in there, referring to designations, which act as a rule in the district plan anyway?
I think the intention of that was just to clarify the initial wording recommended in the 42A report, which said that land transport infrastructure works were permitted where they are undertaken on or behalf of a road controlling authority and subject to a designation. And I was of the opinion that that wasn't appropriate to be included as a permitted rule because it's already covered under the Act. And the suggestion to include it as an advice note was sort of an optional. It doesn't need to be included in the rule, so it's sort of it's at the discretion. I mean, I'm not sure if it's a standard approach to it.
No, I'm not perfectly sure on that.
But that doesn't really give you enough belts and braces anyway, in terms of the additional wording recommended, undertaken by or pursuant authorisation from the road controlling authority. You're going to have a look at it anyway, because in the case of state highways, you're the road controlling authority. So whether or not it's designated or not doesn't really make too much of a difference. All your state highways are designated presumably, or your rural state highways.
Yes, that's correct.
Yeah. Okay. Move to your paragraph 10.5. It's about vehicle crossings onto a state highway. I guess this follows on from my previous point. We were right at the start about whether or not you've got sufficient control anyway to be able to determine. I know when I worked at Transit, precursor to the Wakakatahi, there was a very strong emphasis on reducing the number of access ways to a state highway or consolidating existing accesses in a safer position. So how do you sort of recognise that there is a perception that there may be an expectation that two vehicles are appropriate in a rural zone when really they're not if it's a state highway? Sorry, probably a very convoluted question.
Yeah, would you mind rephrasing it?
Yeah, okay. So you say, in my opinion, a balance is required as to whether the provision may be perceived as creating the expectation that two vehicle crossings are appropriate. So in terms of the relief that you're seeking, you're asking council to consider whether it's appropriate to also apply a maximum in the rural base based on road classification. So how would that actually look?
For example, it might have a maximum that one is appropriate per in the rural zone for a higher order road classification. I think the concern really was that if it's not LAR and there's sort of this underlying expectation that up to two are permitted blanket across the rural zone. Rural zone can include state highway, it can include other roading classifications, that it sort of sets an expectation for applicants when they consult with Wakatahi that two is sort of the baseline, and there's discussion from there. And I appreciate that some state highway is LAR and the preference is to reduce the number of their access ways, but a lot of state highway isn't LAR, so it's just sort of an indication of what's expected by the plan.
But regardless, a new access on a non-LAR highway is going to, you're going to have a look at it anyway.
Yes, that's correct.
For various reasons, there were just, even though there's a road opening notice or whatever they call it now, the access request, because they're doing works physically on the road, would have to come through the agency, wouldn't it?
Yes, that's correct. Through the corridor access request process.
Thank you, that's helpful. And then my last question Your para 10.2.1, sorry, 10.21. We talk about this difference between road frontage and main entrance could be interpreted differently, slightly depending on the reader. Have you got any suggested wording to resolve this, just to make it more crystal clear than it potentially is, as you've outlined here?
I haven't come up with any suggested wording, but I was just interested to hear the intention of it. There were sort of discussions amongst myself and my colleagues when we read this rule, and each of us sort of had a different interpretation. I can provide some suggested wording if that would be helpful.
Yeah, with the agreement of the chair, that would be helpful, because it's all about getting precise certainty, so you don't have particular debate or argument about whether it's where the road frontage is, or whether there's a main entrance, or whether there's a secondary entrance which is for pedestrians and so forth. Just to get a little bit more clarity around that. I think your point's well made, but I wouldn't mind seeing some words, so that would be helpful. Thank you. I've no further questions.
Nicole, any questions? Yvette, any questions? No. So Ms. Watt, I just want to take you back to your paragraph 9.2 at the bottom of your page 8. And you've suggested crossing out A and B and putting in the underlined words in the chapeau of that provision. But you see where you've crossed out B, those matters you haven't moved up there. They're being undertaken in accordance with an approved subdivision, consent, or are subject to a designation. And you rolled the designation into the bottom of the rule, and I'll come to that in a minute. And actually, just John, by the way, just a point for you to think of, maybe that B should actually be split into two. That last part of B is like a separate requirement in my mind, so it would be more usefully cast as a C if that's to be retained. Was there a reason why you didn't move the subdivision provision up?
I'm looking at it now, not that I can think of it. It may have just been an oversight when redrafting the provision.
Sure. And the way that the rule or the provision is currently written, with B saying that the rule applies if you're subject to a designation in the district plan, but then all of the requirements, TRAN, RE, Q1, etc., still apply to you. Your suggestion to put that extra wording at the bottom of those provisions would mean that those REQ requirements didn't apply to a designation, and that would only be appropriate in my view if all of the designations were super modern and they had pages of conditions in them that covered all of those REQ matters. And I know that's usually the case for new NZTA designations. And I was a hearings commissioner on the new road that's replacing the Manawatu Gorge Road, and that designation has a lot of conditions on it. But I suspect that a lot of the designations in this district probably don't have many conditions on them at all, do they?
That would be correct, yes.
Yeah, right, okay. But other than that, no further questions. Thanks very much. So unless there's anything you wanted to add, Mr. Fletcher, that brings us to the end of our questions for NZTA.
We did discuss this provision, so I'm quickly trying to remember exactly what we discussed. I'm probably better to leave it alone because I'd need to review all of those.
Yeah, and it's Ms.
surrounding
White's evidence in
provisions.
any case. So. All right, thanks very much for coming in. That's the end of our proceedings for today. Section 42A reporting team, anything you wanted to clarify with us in terms of you preparing your reply report before we end the day?
No, thank you, Chair. That was very clear.
All right, thanks very much. So that brings us to the end of today's proceedings. Thanks very much, everyone.